All right, we can go ahead and get started. Like I said, we had some amazing music. It was playing in my head, wasn't playing for you. Just imagine the best song that you have ever heard. That was the song that we had playing. We are excited to have you all join us today for Vaccines Revisited. So OSHA issues its Vaccination Emergency Temporary Standards, or what we're calling an ETS, on November 4th. It's published in the Federal Register November 5th. And the very next day, the Fifth Circuit Court of Appeals out of New Orleans issues a temporary stay. Essentially, they say to OSHA, you cannot enforce the ETS. And the stay then becomes permanent on November 12th. Now they're really serious. You can't enforce it until there's judicial review or otherwise a court tells you that you can move forward with enforcing it. With that, many states have also issued bans on vaccine mandates. So there is a lot of confusion out there about the vaccine mandate. And if you're confused, you can bet that your employees are also confused. So we have a lot to talk about today. And then our goal, there is a ton of confusion out there about the vaccine mandate. Our federal government is saying one thing, state and local governments are saying another. The media is adding to the confusion. And if you're confused, like I said, your employees are also confused. And I can tell you, a confused workplace is not a great recipe for high performance or high productivity. Here's our commitment to you today. We are going to help clear up that confusion, and we're going to give you actionable steps you can take to drive clarity throughout your entire organization. So regardless of your political stance, the mandate situation is serious. We can all agree on that. And you have to start dealing with it now. And we know this because we represent organizations of all sizes. We represent organizations with 10 employees all the way up to 1,500 different employees. Scott, you can go ahead and show the next slide. And we help these organizations deal with this mandate. Simply crafting a policy, which we do, is the first step. For that policy to be effective in driving clarity throughout your organization, it has to be backed equally with clear procedures and clear systems. The policy is one step. Putting the procedures and the systems in place and the communication protocols is where you drive that clarity among your workforce. So here's Michael Gerber. He is the author of E-Myth Revisited, which has sold millions of copies, arguably listed in the top 100 business books of all time, E-Myth Revisited. Michael asked me to attend a webinar with him, one of his podcasts. He wanted to know how we used systems to systemize the practice of law, and even more importantly, how we use that to help our clients avoid liabilities and mitigate legal pitfalls. The discussion took systems to a whole new level. That's how we're going to deal with the confusion in the United States today around vaccine mandates, by creating systems and procedures that drive clarity and facilitate high performance. So again, Kevin Harrington, one of the big problems entrepreneurs run into is that they get too comfortable. We are in a climate right now that is not comfortable. We are in a new world. And because we're in a new world, our businesses have to change. Change is scary. We have to get comfortable being uncomfortable. So one of our many clients, IACT Health, engaged us to help them implement the vaccine mandate, because IACT conducts clinical research trials on COVID-19 vaccine. They're the actual company that are doing the clinical trials on the vaccine. They have COVID positive patients in their facility. That means they fall under the OSHA healthcare ETS. Ultimately, what that means is they have to mandate. So we help them not only develop the right policies, but we help them develop a stepwise approach to communicating with their workplace. Out of 100 employees, they lost one. They lost one employee. Now, within their proximity of other hospital systems, we heard of whole departments leaving once they implemented the vaccine mandate because they didn't have the right communication protocol. That's what we're going to discuss today. So in our short time together, we're going to go deep into mandates, how to deal with them successfully, but also you have to put the work in. You have to be willing to give your best. Two obstacles that will stop you is time and fear. You're going to tell yourself you don't have enough time to develop all these new policies and procedures. We understand it's a lot of work, but that's why we're here. We can help you be efficient. We can help you move quickly. we can help you get the right communication protocols in place. And the second is fear. We hear it every day from our clients. They say, man, if I take a stance on the mandate, whether I implement it, whether I tell them there's no mandate, our employees are going to quit in droves. There's going to be mass mutiny. Again, this is a new world. And as business owners, we have to be willing to make changes in our business in order to deal with this new world. And changes are scary, but I'll tell you what's even more scary. More scary is allowing your workforce to stay confused, to stay in a state of confusion where you're not facilitating high performance, where you're not facilitating high productivity. So I need a commitment from all of you here today. I need you to commit to me that you're going to give your best, that you're going to listen to this material that we have prepared for you today, that you will create a COVID-19 policy on this webinar with me today, with the tools that I'm going to give you. And regardless of how you ultimately decide to deal with the mandate, you will commit yourself to driving clarity throughout your organization, to give your workforce confidence that you have this handled. So I want to get a yes right now in the chat, showing me that you're committed to those things. And until I get yeses from everybody, I'm going to start dancing. There you go. All right. This is serious, guys. I need your commitment. I'm committed to you, but I also need your commitment. We've got to deal with this situation together. Awesome. So another key question is, what is your why? Here's a great example of a why. Again, IACT engages to help us, engaged us to help them with this vaccine mandate because they wanted to spend more time improving today's medicine and less time dealing with the rumor mill and low morale and employees not performing at their best. That's their why. That is why they made the commitment I'm asking you to make today. Now, I told you about Michael Gerber. I told you about reading his book. That was a big epiphany in my life, realizing that through systems, we can really make our businesses better. And by making them better, we make it a better environment for our employees. We make it better for us to provide value to our customers. Systems is the key to implementing this vaccine mandate. Even if you're not going to mandate and you're going to make it about personal choice, the communication and the systems around how you handle that with your employees is absolutely critical. So as we go deep into the vaccine mandate, I'm going to show you how I put Gerber's ideas into action, and you'll see how you can do this in your organization as well. All right, so let's jump into the material. We're going to cover the vaccine mandate and updates on where we're at today in the United States with it. We will prepare a COVID-19 policy. We've got a bunch of Q&A. Not only do we have Q&A in the chat, but we also had some Q&A that came up as people registered. They put questions that they had about the vaccine mandate, so we want to make sure we cover those. And then we'll have some closing remarks and announcements. So first, some context. So I'm going to go through this kind of quickly, but I do want you to have some quick context of where all of this came about. 1970, President Nixon signs into law the Occupational Safety and Health Act. That is called the OSHA Act. Scott, if you can go ahead and jump to the next slide. There you go. So President Nixon signs that law into office or into legislation. Out of that legislation, it established the Occupational Safety and Health Administration, what we call OSHA. Their premise was to make sure that no worker had to choose between their life and their job. That was the basic premise around OSHA. They must provide their workers with a workplace that's free of serious hazards, and workplaces must follow OSHA safety and health standards. So their primary mission is a safe workplace. It covers private sector employees in all 50 states. It's either through the federal OSHA or there's a state approved state plan. And if there's a state plan, if you're in a state that has a state plan, that state plan must be as effective or more stringent than the federal OSHA program. So just because you're in a state plan doesn't mean that you don't have the same standards, including the emergency temporary standards. So what about this ETS? This is a mechanism that was provided under the OSHA Act that allowed OSHA to deal with what they considered a grave hazard. They don't define what a grave hazard is in the Act. It is a very exceptional and extraordinary measure. It's only been done 10 times in the history of the United States since the forming of OSHA. And out of those 10 times, in 4 cases, it was completely invalidated. In 1 case, it was partially blocked. Again, a very extraordinary measure that allows OSHA to skip all the rulemaking process, to put a regulation in place and say, you have to comply with it now, and we'll do the rulemaking later. We'll get your comments and feedback later, but we want you to comply with this now. That's what an emergency temporary standards regulation is. It's temporary. It's meant to become permanent later after they go through the rulemaking process. So before the healthcare ETS, the last time they issued an ETS was 1984, and it was completely invalidated. So OSHA has not had much success with issuing emergency temporary standards. So where we're at today, January 21st, Biden issues its first ETS this year. It is a healthcare ETS directed at healthcare services and healthcare support services. That has not been invalidated. There is no stay that is currently in force, and there is a mandate that's associated with that. June 23rd, OSHA publishes its ETS for healthcare employees. So that's when the ETS actually came out. There is other mandates that are also being implemented. One is this interim final rule by CMS. This applies to organizations that work with Medicare or Medicaid. It also mandates that employees have to get vaccinated, and it has strict deadlines on compliance. So in addition to that, why don't we go to the next slide, Scott? Great. So in addition to that, we had September 9th, President Biden releases his action plan. OSHA's vaccination ETS is filed with the Federal Register on November 4th, published on November 5th, November 12th. There's a permanent stay by the Fifth Circuit Court of Appeals. Essentially, they're telling OSHA, you cannot implement that emergency temporary standards until further judicial review, until a court tells you otherwise. And here's what they said in the opinion. The mandate is staggeringly overbroad. The mandate is a one-size-fits-all sledgehammer that makes hardly any attempt to account for the differences in workplaces. The public interest is also served by maintaining our constitutional structure. So here they're referencing a constitutional argument, suggesting that this is not even constitutional by suggesting that personal decisions have to be taken into account. So again, ordered OSHA to take no further steps to implement or enforce the ETS until further court order. Now, regardless of what side of the aisle you're on, this is a political issue, right? You have one side of the party that's taking a specific stance and another party that's taking another specific stance. That makes it political. But regardless of that, we as business owners have to make sure that we're maintaining a workforce that has high morale, that's high functioning, that's highly productive. And in order to do that, we have to think through this confusion that's happening out in the marketplace. We have to think through it from a business perspective, right? Not from a political perspective. The reason I'm pointing these things out and what the Court of Appeals is saying and what the administration is saying is because it adds to the confusion. This is what your employees are hearing. Couple of things to keep in mind though. There's a lot of misconceptions. Your employees might think, man, the ETS was invalidated. No, it wasn't. It's merely been suspended. That's what a stay does. It suspends it pending resolution in the courts. What'll happen next? Because there was several actions that were filed throughout the United States. The Fifth Circuit was the first to deal with it. So they were able to get a stay in place. But there is a process under the federal court system. The federal courts don't want like all, inconsistent judgments that occur at the same level. So they'll consolidate it into one court. It'll be done through a lottery system. So if it gets into a court that happens to have judges that lean one way, you might get a very different result, and this stay could be lifted immediately. Or it might get into a court that has judges leaning another way. I want you to keep that in mind, because just because it's been stayed, just because it's not being enforced currently, doesn't mean that it won't ultimately get enforced. And then eventually it'll get to the Supreme Court. Now, the Supreme Court doesn't have to hear the case. They could simply allow the lower court's ruling to sit. My guess, the Supreme Court will hear the case, because these are the type of controversies that the Supreme Court typically likes to handle. And so ultimately it will probably be the Supreme Court or United States Supreme Court that decides this. All of that said, this is a pretty remarkable display of how amazing our country is. You've got an administration that's trying to do one thing, and you've got a court system that has the power and the ability to stop it. Regardless of what side of the aisle you're on, it can work both ways. Most countries, you don't have that kind of checks and balances. And we get to see the checks and balances that our founding fathers put in place on display right before us right now. But again, all of this adds to the confusion. All of this adds to the misconceptions around, what's happening, whether mandates are legal, whether they're not legal. So when we go on to states, it gets even more confusion. If we look at the OSHA ETS that was issued on November 4th, it's for 100+ employees. And either they have to get vaccinated or they have to submit to weekly COVID tests and wear a mask. So it's not an absolute mandate, right? An absolute mandate means you have to get vaccinated, right? If you're under the federal contractor one, you have to get vaccinated. That's a mandate. This one allows employees to have the option of not getting mandating as long as they submit to weekly tests. Now, employers can go beyond that. If they choose to mandate, they can have more stringent requirements, but this is not a true mandate. That becomes important because we're going to look at how this conflicts with state law. But there is a huge financial burden. Anytime you're asking an employer to pay time off, that's money to the employer. There's a cash equivalent associated to every day that you pay for an employee to have off. Again, regardless of your political stance, the plain and vanilla facts of that is that's a cost to the employer. And we'll get into specifically what this ETS requires. Again, it stayed. So before we do this, there's several questions that have come up around, is this going to apply to employers that have less than 100 employees? Well, this is our Surgeon General of the United States. He was interviewed by ABC. And when he was interviewed by ABC, Martha, don't remember her last name, but a famous reporter, asked him, and this was just a few days ago, Dr. Murthy, if the law survives legal challenges, will the administration be extending the mandate to smaller employers with fewer than 100 employees? And the Surgeon General answered, Martha, certainly nothing is off the table at this moment. Now, if you go back and look at the administration's comments on why they chose 100, it was because they were hedging their bets. I mean, this is just how they write it up. They explain, we chose 100 because we felt like employers with 100+ employees would have better financial resources to implement this immediately. But we're taking a stepwise approach, and we're evaluating, who's next, basically. So the administration has signaled or planted the seed that they are looking to implement maybe something similar for employers with less than 100 employees. What that threshold will be, nobody knows at this point. It would be guessing, but you've got several thresholds under the law, looking at the Affordable Care Act and other laws that have numerosity requirements. 10 is a common threshold, 15 is a common threshold, 50 is a common threshold. That's what was used under the Affordable Care Act. So keep those in mind as we get into understanding a little bit more about what may happen next. All right. So again, more confusion around, what's the impact of this emergency temporary standards and the administration's stance on mandating the vaccine. Now we get into what the states are doing. You've got Texas. Governor Abbott came out recently and put in an executive order that basically banned vaccines. Now, it didn't actually technically ban vaccines. What it said is if you're going to mandate a vaccine, then you have to allow employees to opt out of that mandate if they have, a personal conscience reason or religious belief, or if there's some medical reason for them doing that. Now, there's already required accommodations you have to make under other federal labor laws, like the American Disabilities Act. Serious, firmly held religious beliefs is already something that's prescribed under Title VII. Medical conditions are already prescribed under, the American Disabilities Act. So these are things that are already there. But what Governor Abbott's doing is he's expanding it even further. He's taking out that it has to be a firmly held religious belief. It just needs to be a religious belief. He's adding in personal conscience. There's a lot of ways to read this. So it is an expansion on what's already there, but it technically isn't inconsistent with the ETS that OSHA recently released. If you look at what's going on throughout the country, there's 12 states right now that have some form of ban. Now, again, they're not complete bans. Next slide, Scott. There's actually 2 states that have close to what is a complete ban. Again, we talked about Texas, but if you look at Montana, Montana is prohibiting discrimination based on vaccination status. Now, this is in direct contrast to the OSHA ETS. Under the OSHA ETS, you have to ask about vaccination status. You have to keep a log. Well, if you can't discriminate based on vaccination status, you're not going to be able to implement state law over federal law. Again, adding to this confusion. And how are companies responding? You might think, well, if Greg Abbott's going to put in an executive order that's currently in effect today that says you can't do this, well, wouldn't that affect Southwest Airlines? They're based out of Texas. Well, here's Southwest Airlines' response. They're going to fall federal. They said, according to the president's executive order, federal action supersedes any state mandate or law, and we would be expected to comply with the president's order to remain compliant as a federal contractor. So they're going to ignore Greg Abbott's executive order, even though they're based right there in Texas, adding more to the confusion. Now, I want to keep something in mind here. There are 1 million plus laws throughout the country, labor laws, that are state laws or local laws that are in direct contradiction to a federal law. Millions. It's not a problem because in most cases, federal law preempts state law and local law. Give you an example, Georgia. If you're following Georgia law, Georgia says the minimum wage is $5.15. If you're paying your employees, as long as you're paying $5.15, you're good. Was that true? No, we know that's not true because there's a higher minimum wage under federal law. We follow the federal law because federal law preempts state law, right? So this is a common situation where you've got contradictory federal laws and state laws. But what you're going to see there in the media and what you're going to see some of these governors saying is that they're going to challenge the preemption. What they're going to challenge it on is constitutional grounds. You already saw the Fifth Circuit kind of hedging towards a constitutional challenge. Obviously, if the federal law is unconstitutional, if the federal government didn't have the power in the first place to issue it, then it's not going to trump or preempt state law. So again, more confusion. So what's the path forward? Well, here's a clear roadmap. 4 steps. The first step is you need to decide, will you mandate? Couple of considerations here. 1, are you subject to the vaccine mandate, right? IACT Health, one of our clients, as I mentioned, is clearly under the healthcare ETS. They are subject to a mandate. And so they must follow specific protocols that are under that ETS. Southwest Airlines said, hey, we're a federal contractor. We're subject to that mandate. We must mandate. Secondly, are you prohibited from mandating? You might be in a state that is effectively prohibiting you from mandating, even though there's 2 that are directly on point. There's other states like Indiana that are prohibiting you from asking about vaccination status. It's going to be very difficult to mandate if you can't gather data to verify whether people have actually received the vaccine. So looking at state law. Third, assuming that you're not prohibited from mandating or you're not subject to a vaccine mandate, you as a business have to decide, basically you have 3 options. You're going to mandate vaccines, you will strongly encourage vaccines but not mandate, or you will promote personal choice. Looking at the Fifth Circuit Court of Appeals opinion, that was all about personal choice, right? There are ways to do this. Regardless of the decision you make as a business, whether you mandate, strongly encourage, or decide to promote personal choice, there's a way to do it that is a more effective way to communicate that decision to your employees. Secondly, if you're going to mandate or strongly encourage, you have to decide whether you're going to verify vaccination status. Why would this come up? Well, for example, you might be a business that's going to strongly encourage. You don't have a mandate, but you're going to strongly encourage your employees to do that. And by encouraging them, you may have a face mask policy that says, if you're not vaccinated, you have to wear a face mask. Well, how do you know if people are vaccinated? You're going to have to verify their vaccination status. So there may be a situation where you still have to verify vaccination status, even though you're not technically issuing a mandate. So you must keep that in mind. That's a decision you need to make as a business. First 2 decisions. Once you make those 2 decisions, then you need to prepare the policies and procedures. Even if you're not going to mandate, even if you're going to make it about personal choice, you should have policies and procedures that talk about face masks, testing, PTO, record keeping. Again, your policy may be you don't have to wear a face mask, right? But you still need to have a stance on a policy that you communicate to your employees. If you are going to mandate, or you're going to have incentives, you're going to strongly encourage and have things like whether you wear face masks or not wear face masks, there may be an accommodation process that you have to take into account. That's an entire process and procedure that you need to put in place. And then recruiting. There's going to be lots of issues around what you can ask employees or candidates, what you can't ask candidates. And we're going to get into some suggestions there as well. And then fourth, it's communication, communication, communication. No matter what choice you make, whether you mandate the vaccines, whether you strongly encourage, or whether you promote personal choice, You need to communicate your decision to your employees in an effective way. They need to know, because if they don't know, they're going to remain in confusion. And if they remain in confusion, you are getting in the way of having highly productive employees and having a high performance culture. Communicate and communicate, communicate. Your employees want to have the confidence that you have this situation handled. Rather than adding to the confusion, you're driving clarity throughout your entire organization. So let's get into some specifics. Do you have to mandate? Well, again, the OSHA ETS has been stayed. We have several clients who are over 100 employees who plan to go ahead and begin putting the process in place to comply. So in the event that it does go into effect, they're ready to go. Understanding that, you might want to look at some exemptions. First of all, employers that are subject to the healthcare ETS, like IACT, they are not under the OSHA ETS. I would prefer them to be under the OSHA ETS because there's a lot less requirements under the OSHA vaccination ETS that just came out, but they're under the healthcare ETS. Federal contractors and subcontractors. So if you take federal jobs, you're likely under the Task Force COVID-19 Workplace Safety Policy, which means that you have to mandate. And if you are not under the recent vaccination mandate. So basically what the government's done is they've said, we're only going to hold you to one standard. We're not going to make you comply with a bunch of different standards. So once you determine if there is an emergency temporary standards that you fall within, right, then it's that one that you have to comply with, not these other ones. And then specifically, if you have employees who are who don't report to a workplace where you have coworkers or customers present, then those employees are exempt. Now, this is important, right? So you have a bunch of requirements under the emergency temporary standards, and that's going to apply to your workforce. But there's specific employees within your workforce where those standards may not apply. And specifically, they're not going to apply to a purely remote worker, somebody who's not in contact with other coworkers, or who is not in contact with your customers. They're working from home, or if they're working exclusively outdoors, they're not going to apply those employees either. But those employees do count towards the 100 threshold. So let's say you have 50 remote workers, right, who are purely remote, and you have 50 workers that are not remote, you will fall under the OSHA vaccination policy or ETS. Why is that? Because the administration didn't pick the 100 threshold because they didn't think it should apply to organizations that had less than 100 employees. That wasn't their consideration, right? They picked the 100 threshold because they were hedging their bets. They knew they were going to be challenged, and they felt like if they picked 100, they would have better arguments for saying, you know, why this isn't a financial burden on these employers. So the whole counting towards, you know, that 100 threshold is just about picking a certain size organization. It's not about, you know, well, we only have 50 employees who might be in harm's way. That's not the consideration here. So they are counting those employees towards the 100, but those specific employees, if they're purely remote or purely outdoors, you would not be subject to the ETS with regards to those employees, but your other employees you would be. Okay, it's a little confusing on that. Hopefully I was able to clear it up. So they get very detailed in this emergency temporary standards about what is an approved COVID-19 test, what's an approved face mask, what's an approved vaccine. With your COVID-19 test, essentially, if it's authorized by the FDA, including through an emergency use authorization, then that's a valid COVID-19 test. Essentially, any sort of COVID-19 test that, you know, is commonly sold or used is going to be authorized. Face masks, they've got to completely cover your nose and mouth. They have to be secured, and there needs to be 2+ breathable fabrics. Now, this is really specific, but it's really the same standard that you have in airports when you have to fly on planes and so forth. So most of the face masks that you would purchase today is going to meet this definition. And then the vaccine, this is really key. They show up with their vaccine card. They say an employee shows that they have had the 2 doses. That doesn't mean they're fully vaccinated. Under the emergency temporary standards, it's 2 weeks after you've received your last full dose of the vaccine. And again, it's got to be a vaccine that was approved by the FDA or authorized under the emergency use authorization. All right, financial burden, paid time off. Employers must provide up to at least 4 hours of paid time off. That's including travel time at the employee's regular rate of pay to obtain the vaccine doses and paid sick leave to recover from the side effects. Now, if the employee has accrued PTO, right, they've got vacation, they've got other PTO, you can apply that PTO towards this. You don't necessarily have to give them an extra 4 hours, but if they used up their PTO and they go out to get the vaccine, you're going to have to give them extra hours, right? So there is a financial burden towards this. Again, every paid time off day you provide to an employee has a cash equivalent. It costs the business money. And so this is part of the financial burden that comes along with this emergency temporary standards. Record keeping requirements. You're going to have to, if you're going to mandate and you're going to be under this emergency temporary standards, then you're required to determine the vaccination status of all your employees, including documenting which employees are fully vaccinated, looking at their vaccination card, maintaining a roster. It's not too dissimilar from E-Verify, right? If you have new hires, you have to verify that they're eligible to work in the United States. You've got to look at certain forms of identification. They have a worksheet. It says you got to use this form or this form. If you don't have this form, then you got to check these two forms, right? There's a whole process you have to go through to verify their eligibility to work. Not too different than that, but you've got to verify that they're vaccine. Now, you don't want to get too into verifying, right? Just looking at the vaccination card is all you really want to do. Their name, that they went to an appropriate clinic or wherever they got their vaccine and the dates. But going beyond that, like understanding medical history or those sort of things is where you're going to get in, thorny legal trouble. Record retention is also going to be important, but it's not the same record retention that's normally under the OSHA standards. At the moment, it's just a requirement to retain those records while this emergency temporary standards into effect. Now, if it goes into a permanent regulation, they may have different requirements around record retention. So at the moment, all that's required is to retain it while the emergency temporary standards is in effect. Testing. Employees who report to work in a 7-day period must be tested if they're not fully vaccinated. Let's say they're away from the workplace for more than 7 days. They're not near customers. They're not near other coworkers for like 30 days. They're remote, or they're working in a place that's not around other coworkers. If they're going to come to work for a meeting, then in the 7-day period before they show up to work, they need to get tested. That's how they're doing it. It's a 7-day time frame, right? Before you show up, you need to have a test within the 7-day period before you show up to work. Or if you're regularly going to work, then every 7 days, you've got to get tested. And if you're not tested, then you have to be removed from the workplace until you present a negative test result. Test results have to be maintained as medical records. You're already doing this, right? Medical records that you have in response to like FOMA or health insurance or those sort of things. There's already requirements under the Fair Labor Standards Act on how you deal with medical records. It has to be dealt with separate from the personnel file. This is just dealt with as any other medical records you might keep on an employee. It's confidential. It's in a separate file. It's under lock and key. There's specific requirements on how you deal with medical records under the Fair Labor Standards Act. Employers don't have to pay for tests. That was a big if. A lot of people thought when the emergency temporary standards came out that you'd have to pay for the test. Clearly, they knew that was going to be people were going to be complaining about that. They're expensive. Employers do not have to pay for PTO while the employee is removed. So if it doesn't have to do with getting the vaccine or recovering from side effects, then there isn't an affirmative obligation to pay for time off. Face mask. It's only required for employees who are not fully vaccinated. You do not have to wear a face mask if you're alone in the office and the door is closed. Now, when I say the emergency temporary standards is specific, it's very specific, right? So I'm reading it and it's like, well, so if I leave my door open, even though I may be like 12 feet away from anybody, technically under the emergency temporary standards, I've got to wear a face mask. So it's only with your door closed. I don't know about you. I don't like it when my employees have all their doors closed. It's not the kind of office culture that we promote, but that's in the emergency temporary standards. You can have your face mask off while you're eating or drinking, or if the employee can show that it presents some serious risk of injury or death, based on the job duties, then that might be a situation where they don't have to wear a face mask. And there may be certain situations, certain job duties where it would pose a serious injury or death if they had their mouth and nose covered up. All right, penalties. They're pretty big. It's $13,563 for every single violation each day for failure to abate the violation. So you can imagine a single violation could be multiple employees, right? Like say 10 employees, that could be 10 violations. 10 employees are not complying each day. Those violations are going to add up. You could be 100 times $13,563. Typically, when OSHA comes and assess penalties, they assess you for everything. Then they might negotiate. They'll give you like a whole list of things. We deal with a lot of OSHA audits for our clients. We help defend them in those OSHA audits. You'll get a whole long laundry list of like every single incident of a violation, and there's going to be a penalty associated. And then it's typically you're negotiating with OSHA, and they're agreed, okay, well, maybe that wasn't a violation or that wasn't a violation, and that's how you're reducing the penalties. Compliance is required by December 5th. Obviously, that's not the case while it's stayed, while the Court of Appeals have told OSHA they can't implement it. And it was January 4th where employees would have to start submitting to weekly testing if they weren't fully vaccinated. Again, according to the federal government, this preempts state and local law that will be challenged and likely challenged on constitutional grounds. All right. So that's kind of a big summary of what's in the policy. What's key about this is if you're going to mandate, right, and you don't fall underneath the OSHA ETS, then even if you want to comply with the OSHA ETS, you're going to have a little bit more latitude about how you enforce these things, but it's going to be a good idea that you have all of these components dealt with in your policies and procedures. You have something on face mask. You have some detail around how you deal with face mask, when you can remove face mask. You have detail on testing, whether you're paying for testing or not paying for testing. You've got to discuss paid time off. All of these different components need to be in your policies, and then they need to be incorporated in your procedures. If you're going to strongly encourage, and you're going to have different things in there about wearing face masks if you're not fully vaccinated, again, these different components should be touched on. And if you're not going to mandate, and you're going to make it about personal choice, then you still need to touch on these things. It may merely be telling your employees that they're not required to wear face masks. Again, it's about driving clarity within your workforce so they understand the position from the business. And when you talk about these things, you've got to avoid politics, right? If you're going to talk about it being a personal choice, we have in our policies, for example, we have clients who have made that decision. We still discuss that we're committed to a safe and hazard-free workplace. That here are the things, and we put examples of all the things that we're doing to maintain the safety. We've got cleaning protocols. We have sanitation protocols, that we're taking this seriously. And the last thing we want to do is facilitate the spread of infectious diseases. So all of that language is in the policy, but they're taking a stance that, you know, whether you choose to get a vaccine is a personal choice for you, right? So there's a way to communicate in a way that in an effective way. Again, whether you choose to mandate, whether you choose to strongly encourage, or whether you choose to make it about personal choice. All that being said, if you're going to mandate, there are some accommodations that you have to be aware of. One is reasonable accommodations must be made if an employee can show that the vaccination shot would worsen his or her medical condition or pose a danger. This is a bit easier to deal with because they're going to have to go get a medical professional to write a note that's basically going to verify this, right? You're not a medical professional. You don't have to verify this. And as long as you can see somebody who is, who's got the skill and the knowledge and the expertise to be able to opine on this, then that's the way that you can verify that an accommodation should be made. The next one has to do with seriously held religious. And again, before we even get on that, you can inquire about symptoms. You can take temperatures, which technically is a medical exam. So there was a lot of confusion around that without violating the American Disabilities Act. Again, that whole accommodation comes under the American Disabilities Act. The EEOC has responded to this, and they're making some exceptions because of their view of the situation with COVID-19. So Title VII also adopts a very broad definition of religion, and they require employers to accommodate an employee's firmly held religious beliefs. Now, this isn't new. This didn't come out because of COVID. This has been an accommodation that has to be made under Title VII for a long time, right? Since Title VII has come out, because you can't discriminate based on somebody's religion. It obviously comes into play because there are certain employees who may have a firmly held religious belief around getting vaccinated. And if that's the case, then this would require you to make an accommodation. But this is a little thorny, right? You don't have a doctor, for example, who can opine on this and just fill out a note and say, an accommodation needs to be made. You're more in a position where you have to evaluate the request being made. This is where procedures and systems are really, really important. Having a system and procedure and having the questions that need to be asked, right? Instead of you just kind of coming up with questions at the last minute is going to be absolutely key. So you can make sure you get the right type of information to allow you to do an appropriate evaluation. And again, you're going to come under this when somebody makes a request like this under the assumption that they do have a firmly held religious belief. And it's going to be a situation where they say something or they put something in that form that makes you realize that this is something they just decided, hey, my religious belief came about 2 days ago when, OSHA's ETS, when the state got removed, and now we're under OSHA's ETS. And then that's when I formed my firmly held religious belief. That clearly wouldn't be a firmly held religious belief. So those are things that we can help you with. We help our clients with this every single day. Next slide. All right. So again, the EEOC is taking the position that these laws do not interfere with you following the guidelines or suggestions of the CDC. So they're kind of they're planting the seed that if an employee brings a claim and that claim is based on you following a CDC guideline or some local public health authority guideline, that's not going to be a claim that's really going to get much traction with the EEOC. So what are accommodations you might make? There's kind of a two-part thing. Is there a requirement to make accommodation? If so, right, if you're unable to make the accommodation without severe financial burden, then in that situation, you may have to suspend the employee or terminate the employee, right? That the employee can't do the job functions that you need the employee to do. So if that's the case and the employee brings a claim, they're going to argue that you didn't make a reasonable accommodation. And so what might be a reasonable accommodation? Well, enhanced protection measures. Instead of having the employee vaccinated, you have them wear face mask, you have them, stay within, more than 6 feet from coworkers or customers. There's different things that you can do there. Remote work. If the employee can actually do their job remotely, having them work remotely might be a way that you can accommodate that request. If no accommodation is required, then that would only be because you've determined that it poses some undue hardship or poses some direct threat to the health and safety of others. It's a financial hardship that you can't bear, or it's going to put other coworkers in jeopardy, their health or safety. And there may be temporary modifications to work schedules where you can have them work at hours where there's not many coworkers around and they can stay, more than 6 feet apart. So those are accommodations that we help our clients with when these requests are made. Here's an example. What we'll often do is we give them sort of three options. You got your low risk option, your medium risk option, your medium to high risk. And this is when an accommodation is made. We're helping them understand, like, here's a full accommodation if you were to provide it. Here's a partial accommodation. And here's what it likely looks like if you make no accommodation at all. Again, giving you good information so you can make a good choice. And that's part of the systems and processes that we put in place. So when they reach out to us, we already have all the information we need and we can help them get to a good decision on an accommodation. All right. A lot of this came up in the Q&A. Testing, you can't require antibody testing. That's testing where you're determining whether they've received received COVID before. That does get into thorny legal pitfalls. So it's a different type of testing than just a normal COVID-19 testing. And there's other considerations as well. And these are some of them. We're going to have these slides available for you so you can kind of go through all this information too. All right, so we've got the last 10 minutes. I want to take a few minutes to draft a policy. Now, you made a commitment to me today, and the commitment was that you were going to give your best, that you're going to implement this material. I made a commitment that I was going to give you a clear path and action steps for doing this. We're going to draft a policy. It's going to take less than 5 minutes. I need you all to participate. By participating, one, we're going to get a bunch of feedback. We're going to see what worked and didn't work about our software. And by participating, you're going to get an actual policy. You will be able to get that policy in Microsoft Word. There's going to be a question that's going to ask you what format. You can put PDF, Microsoft Word, or both. I would put both. You can get the Microsoft Word. That'll allow you to make changes. So even if you don't get the policy perfectly right today, you can go in and modify it however you see fit. You can get us engaged to help you modify that to better account for your business. But I have a feeling that if all of you do this, the 85 of you that are on this call, if all of you do this, it's going to be 85 different policies. This software we developed is like legal Zoom on steroids. Instead of giving you just a generic form like LegalZoom does when you fill in your information, you're getting a custom tailored fit policy based on the legal risk that the software identifies as you fill out the form. It's really, really amazing stuff. And I mentioned Michael Gerber when he asked how you're systemizing this. This is how we're systemizing the practice of law. And this is how we're systemizing it for our clients so that they can avoid legal pitfalls and so that they can be in compliance and they can use systems to help them mitigate their liabilities, right? And this also allows you to get this stuff a lot quicker, to put things in place a lot sooner, and to get the attorney help that you need. So we're gonna go ahead and do this. 3 quick steps. Go to scott.inprimelegal.com. The password is shot in the dark. May or may not be based on an 80s song. There's gonna be a white screen that comes up. You're gonna put shot in the dark, and then you'll see draft a contract. There's several contracts, all of them work. But what we're drafting today is the COVID-19 vaccination policy. You're gonna be on your computer. I need your commitment to do this with me so we can get your feedback. We can get something in your hands that has value, right? Now, in just a few minutes. Go there, and the first person to finish, go ahead and put your name in the chat box. We're going to be sending you a bunch of success books that we've sort of combined that all deal with, some of the best books in HR. So go ahead and go in there, and you've got 5 minutes, and we will resume in 5 minutes. When we come back, we're going to be doing the Q&A. We've got a bunch of questions, some really cool questions that people asked. We'll get into those, and then we have kind of some final moments. And Alan Keats is here as well. Alan didn't speak up. He was just so intrigued in everything I was saying. But Alan is a Vistage chair. He's my mentor. He is my coach. He's my wife's coach. He is an HR professional by trade. So he came out of the HR world dealing with hundreds and hundreds of employees. He was kind of the top dog in charge of the entire HR department. A ton of knowledge. When we get into the Q&A, we're going to bring him in there as well, so that he can help kind of field those questions. And we'll be back here in a few minutes. So as you fill this out, my hope is that you find it very simple and easy and intuitive. But I'll tell you, it was hundreds and hundreds of hours of back-end development. We internally developed this software. It's not something that we went out on the street and purchased off the shelf. Every question that you're answering every word of every question you're answering are words that we wrote. The COVID-19 policy, people pay us $1,500 to $5,000 per legal document. That would cost somebody maybe $2,000, $3,000 with all the attorney time, the consultation, drafting the policy, helping them put it in place, the communication protocol. It's just a lot of time that goes into that. And you're literally getting the policy we would draft in 5 minutes, right? Because what we're going to do as an attorney, hey, Alan.
Hey, Jonathan.
If I was, if you and I were in an attorney consultation, right? You were my client. Basically, 3 things are going to happen, Alan. I'm going to ask you questions. You're going to give me answers. And then you're going to ask for an explanation. And if you ask for an explanation, it's really because you didn't understand the question and you need to get to an answer, right? That's what our contract sprint does. It simulates an actual attorney consultation, and then I'm going to go take all that information and draft a policy. The software then drafts the policy based on the information it gained. Pretty cool, pretty simple. All right, do we have somebody in the chat box? Yes, looks like we had, has the first person gone in the chat box? Scott? All right, perfect. So we got our winner. We will go ahead and get you all of that success books, specifically HR books. Alan and I will kind of compose that for you. So Alan, let's go ahead and get into some Q&A.
Okay. Can I give you one or two that, because we've processed this as issues with CEOs already. Can you get into the 100? So I have CEOs that own many locations. How do you determine 100 employees? I know it seems obvious because there are people that only own one company.
Right.
But if they own a couple companies or a couple locations, how is it common ownership?
It's common ownership, and this isn't new. So where this came up before under labor law is overtime. You would have a company that would have an employee work at one location, and then they would have a different location and a different LLC, right? Different operating agreement, technically a different company, many times even different payroll, like a different payroll process. And so they would send the employee over there to work, and they would say, well, that's not overtime. They work 20 hours there and 30 hours over here, two different companies. I happen to own both of them. And the Department of Labor said, nope, that's enterprise, common ownership. You know, you have control. So they're looking at control. You could have controlled that and made sure that they didn't work over 40 hours, or if they did, that you were going to pay them overtime. So it's going to be the same case here. They're looking company wide. And again, that 100 threshold wasn't because there was like 100 was some magic number where they felt like that's where the risk of COVID is. It had nothing to do with that. It was more about hedging their bets and saying, if you're an organization of that size, then you're in a better position to bear the financial burdens of this.
And the other big question, Jonathan, is, say one of your clients says everybody that comes in here has to be vaccinated. I'll give you a case in point is I have people that do work at Piedmont Hospital.
Yeah.
Right? Piedmont has said everybody that comes in has to be vaccinated. I have a person, their only job is Piedmont Hospital. They won't get vaccinated. What do I do? Okay.
So first of all, Piedmont likely doesn't have much options around that because they're under the healthcare ETS, and under the healthcare ETS, if you provide healthcare support services, right? And those healthcare support services are performed in the healthcare setting, then you are also subject to the healthcare ETS, which means you have to mandate for those employees that work in the healthcare setting. So when Piedmont tells you that, it's likely because that's the requirement under the emergency temporary standards that's in place today that has to do with healthcare. With that said, it's like anything else. If you said to your employee, you know, we fix cars and our shop is outdoors, and so when you fix cars, you have to do it outdoors, and the employee says, no, I just don't work outdoors. You got to get rid of that employee. They can't perform the job that has to be done. And that's the sad reality of this. If you have customers who require your employees to be vaccinated if they step on site, you as an employer have to make a decision. Are you going to keep that account? Right? Are you going to comply with your customer's conditions so that you keep the revenue coming in for that customer? And if you're making the choice that you are, then, and the customer requires that as a condition, and if it's under like some federal mandate, then if your employee's not willing to do that, and you can't make a reasonable accommodation for some other job site that's not requiring that, then you're not going to have work for that employee.
And any suggestion on what do I suspend? Do I lay off? Do I terminate?
So ultimately, you can suspend. It's the same thing as termination, basically. They're not on payroll. They really don't have a job. But you know, what we counsel our clients through is like, is there a way that you could repurpose this employee? Is there some other job that they could do? Because we're in a market right now where talent is just almost impossible to find. So you want to retain your workplace. And if the answer is yes, there's some other job I could probably use this employee in, And we have this situation right now with several of our clients. And ultimately they came to the conclusion, yeah, we do want to keep the employee. We're working on a communication protocol on how to help that client communicate, what the requirements are, that these customers do require them to be vaccinated, a reasonable request type procedure that's separate from like firmly held religious beliefs and, medical conditions, but just, a request around, I don't want to, work with this particular customer. And then looking for opportunities to kind of repurpose their job duties so that they can still get a return on investment on that employee.
Got it.
But ultimately, if you can't do that sort of stuff, it's going to be termination, right? That employee is not going to sit at home without a job. They're going to go get another job, right? And they're no longer going to be employed with you.
Thank you.
So, yeah. So I think we've kind of answered a couple of those questions. 2 IEN numbers, not determinative, right? If there's common control among those companies, they're likely going to be considered part of one company in terms of 100 employees. And I've got to move this this chat box because I can't see this. It's not calculated the same necessarily under the Affordable Care Act because you have like part-time equivalents and those sort of things under the Affordable Care Act, full-time equivalents. They're just counting employees. So they're looking at your payroll and they're looking at when you get to 100 employees. Does the business owner need to combine all the affiliates under common ownership? Likely, yes. The conservative approach would be to assume that any kind of subsidiary or affiliate that you have under common control is going to all be considered, one big enterprise in terms of counting employees. And so that has to do with the employee counts. Scott, what's the next FAQ there? So does it impact? We talked about remote employees. If they're fully remote, the ETS standards don't apply specifically to that employee, but if they're going to come on the job site, they're going to be in contact with customers or coworkers, then at least for that one day that they're there, 7 days previous, they need to get tested if they're not fully vaccinated.
Hey, bro, I'm in the middle of.
All right, so those are those FAQ questions. Is it legal to ask an employee about their vaccination status? Absolutely legal. The EEOC has opined on this. Now, how you do this, right? Kind of 3 methods. First is you could ask about it in an interview. We don't recommend that because it often leads to questions that aren't permissible. Like, well, why haven't you gotten your vaccine? Why have these medical conditions, right? You don't want to get into that sort of dialogue with them. Another better way to do it would be to, the safest way to do it would simply be to attach your policy. I mean, when you're going out there and advertising for a job, you can let your candidates know that you mandate the vaccine, right? And you can even attach your policy so that they can read it. And if they're not vaccinated, they're probably not going to apply. You haven't singled anyone out by doing that. You've simply said, this is a policy that we have in our organization. We want you to be aware of it when you apply for this job. And then another way you could do it is you can ask about it in writing, right? If there's some sort of application that they fill out, one of the questions could be, have you been vaccinated? The reason that's safer than simply asking about it in an interview is because you can't get in trouble they can't come back later and say that you asked them impermissible questions, right? That it's very clear that you asked them this question and this is exactly how you asked it because there's a written record of the questions being asked. So again, 3 ways you can do it. In the interview, which we wouldn't recommend, attach your policy to your job posting, or third, ask it in writing, put it in the actual employment application so it's very clear what the answer is. So regarding hiring, is it legal? So there is a lot of talent entering the job market that's unvaccinated. Again, you have to make a decision about whether you're going to mandate, strongly encourage, or you're going to make it about personal choice. And that may factor in your decision. But what we want you to do is to be clear about it, right? We want you to have clear communication with your employees so you drive that clarity within your workplace so there's no confusion, right? They know exactly where the company stands. It's not a political stance. It's done in a soft way with the right kind of communication strategy so that your employees aren't, listening to the confusion that's out there in the market, but have the confidence that you've got this handled. All right. So I think we're past time. We've got a lot of noise going on. That's them telling me that we're past time. So the Supreme Court will weigh on this, and in all likelihood, they don't have to, but they will, because this is a pretty serious issue. So Scott, we're going to go ahead and move to the very last slide and just announce the next webinar. All right, so our next webinar is going to be on the Employee Protection Program. It's how to implement an Employee Protection Program. This is about going beyond your employee handbook. It's the training, it's all the procedures that you need to make your employee, to really mitigate discrimination claims. And it also goes a step further to kind of promote retention, to promote this high performance, to let your employees know that you're on top of these things. So we call it our Employee Protection Program. We've had a ton of success with our other clients, and we're going to be discussing that on our next webinar. Have an awesome day.